Thank you all so much. If we're going to get started with panel 2. And moderating panel 2, we have Professor Julia Simon-Kerr. She is the Evangeline Starr Professor of Law at UConn Law, where she teaches evidence, civil procedure, and law and lying. Professor Simon-Kerr is a leading scholar of evidence. Her work on credibility and lying in the law lies at the intersection of evidence theory and critical legal perspective, and she also influences reform. Thank you so much to Professor Simon-Kerr, and we'll kick off panel 2.
Thank you. So I'll do some brief introductions, and then we want to get straight to hearing from our panelists. And I'm just going in no particular order, because that's how I wrote them down. So we have Aziz Bahsin, who is a postdoctoral associate at Boston University Law School. She also served as the Law and Policy Fellow for Evidence Equity at the Center for Anti-Racist Research. And her own research focuses on the use of expert witnesses to prove racism in criminal trials, which we'll be hearing about. Andrea Dennis is the Martin Chair of Law and Associate Dean for Faculty Development at the University of Georgia School of Law and co-author of Rap on Trial, which examines the use of rap lyrics as evidence in criminal trials. Anna Roberts is a professor of law at Brooklyn Law School and the co-founder of the Coalition for Prior Conviction Impeachment Reform and a prolific scholar of evidence. Jasmine Gonzales Rose is professor and associate dean for equity, justice, and engagement at Boston University Law School and a founder of the Abolitionist Law Center and a leading criticalist evidence scholar. And Maneka Sinha is an associate professor of law at the University of Maryland School of Law, where she directs the Criminal Defense Clinic, and she is an expert in forensic evidence and has examined that topic from a critical lens. So we're so honored to have all of these panelists with us to talk about reform.
Okay, so I guess I'll just kick it off. Thank you, Julia, for those introductions, and my panelists. I'm so delighted to be here with all of you, and the first panel was immensely stimulating. I was saying to Bennett, Professor Capers in the back, that I had my notes prepared, but then so many more themes and threads that I wanted to pull from the first panel to this one. And of course, thank you everyone who's here to hear us marinate on the topic of critical evidence. So as you all have heard, or maybe you knew, I come to this having written about rap music as evidence in criminal adjudication, rap on trial. I apologize for those of you who were expecting me to talk sort of substantively about sort of that work and that research, right? This is the reform panel, so I'm mostly going to talk about reform and not really walk through my thinking about that as sort of a logical evidence criminal defense matter. But I will say, certainly many of you know about the YSL case going on in Atlanta. The word RICO was mentioned in the last panel, right? That's another RICO case coming out of Atlanta. There are several of them. There's also the YNW Melly case in Florida, which is about to undergo retrial. So those are two of the most popular current cases involving well-known celebrity artists. I have to say, over the years, I've been asked about many high-profile cases, and I'm much more concerned about the multitude of cases that go unrecognized in the system, right? There are hundreds, I would say thousands, I think fairly confidently, of or tens of thousands or hundreds of thousands of individuals who are accused of a variety of crimes, and their rap music or their creativity or their social media postings are being used against them. And I'm far more concerned about those individuals who don't receive this same level of attention and don't have the same resources for, right, their representation. And so I always want to make sure that people keep in mind it's not the high profile cases that are as worrisome, right? It is all of the unknowns, the unseens who are undergoing the same challenges, right? And so Certainly, Connecticut is not without its own cases. As was mentioned, there are a couple of cases, high-profile federal prosecutions that are ongoing currently, and there are other state and federal investigations that I know of are ongoing. So this is also a very local issue for you all, so I'm glad to be here to talk about that. I did want to say, at least in terms of background, to set up what I'm going to say about reform is, right, even though this is a very current and relevant topic for many because of the news media, right, I've been thinking about this since the early 2000s when I was first in practice. And then as an academic, I began researching in 2006, right? So this is an issue for me that is, 15 years old, at least. Right? There had been one student note written before that. There had been one psychological study, but it was a relatively unexplored issue. To me, it was a quirky issue. What I thought was a one-off, and then I began to dive deeper and realize it was not a one-off. And then obviously over time, it has exploded in terms of what we are able to take a look at and study and how we can think about this. So that first article I wrote was really just my effort. It was the first article I wrote when I entered academia. So for those professors in the field, you sort of understand what that means. For those of you who are thinking about academia, right, you will discover what that means. But really my effort there was to try and do some interdisciplinary work and resolve an issue that I saw demonstrated a lack of equity or parity within the criminal adjudication process, right, or asymmetry, right? Why is it that the government was completely permitted to offer a gang expert to opine on what rap music's lyrics must mean, circumstantially or directly, about the accused's criminality, and why weren't defense attorneys challenging in ways that I thought were quite obvious, right? And so I wanted to bring the lens of poetics, right, which is an actual subject of study, whether you're in discourse analysis or whether you're in literature or English, right, or creativity or the arts, right? But this subject of poetics and demonstrate how it does or should complicate or frustrate criminal litigation and evidence rules and logic, right? And so that was a really straightforward piece, just thinking about how the discipline of poetics and how we should think about creativity, right, and their intersection with 404, 404B, 403, and the 700s, and what that might mean for the adjudication process. It probably more broadly was aimed at or beginning to think about how the rules of evidence were not designed to or could not address creativity, culture, and Black expression. Right, I dropped a footnote, as we usually do, carving out some other topics about unconscious bias and the First Amendment. We need to think about those too. So that was the beginning of my thinking about this. To Bennett and Jocelyn's point on the last panel, right, I was thinking about prosecutorial ethics, right, their aggressive use of evidence without thought, without mindfulness. Right, the criminal defense response that seemed quite lacking, and why judges weren't engaging in what I thought was their critical analysis, which they were called to do, right, under the evidence rules. All of this seemed so apparent to me, but I put it aside until, fast forward, my co-author, Eric Nielsen, an English professor and right, researcher in Black literature, reached out, and we started then collaborating on this, right? He became the expert that I had called for, right? That in the article, I suggested that there should be experts on rap, right? Who are actually, right, well-versed and knowledgeable in that discipline, right? Not just law enforcement gang experts who have no training in the field. And so he became that person. And eventually, obviously, we wrote the book, which deepened what I had started and added to the conversation the First Amendment question, the question about surveillance in all its forms, both on the ground, in the streets, and then as well online, right? And this was probably the first effort to explicitly connect that topic to or create a critical lens, right? Also in the book, if you read it, buy it, it's great, it's awesome, in any event, right? The effort was to connect it to a long-standing criminalization and use of Black expression and creativity, right? within the criminal adjudicatory system, right? This issue of rap music is not new, right? If you have a history and understanding of Black expression, Black association, right? If you understand jazz, or actually we should go further back, right? Drumming, right? From those persons from the continent of Africa who were, right, forced, trafficked here, right, who brought with them their drumming, right? And yet that became outlawed as a form of, or a concern of communication to incite violence, to incite rebellion, right? So this is part of a long-standing tradition. So that was the first effort to really connect this to questions of racial justice and have a critical lens. So I say all that just to give you a background for why and how we think of the reforms. If you do want more thought about sort of all of that, right, my article, Poetic Injustice, is still out there, right? The book is still out there. You can listen to, if you like podcasts, NPR had a podcast years ago, Louder Than a Riot, season 1. Really explored this issue. Jaya Lee wrote an article that I collaborated with her for the research on for the New York Times. This rap song helped send a 17-year-old to prison for life. If you want to avoid the New York Times firewall, go to Type Investigations, type like TYPE, investigations.org, and you can find our article, Not Behind a Firewall. And then there's rapontrial.org if you want just more information and resources and data, so on and so forth. So I say all that to say that's out there and available. Because what I'm supposed to talk about, and I'll do now, are reforms. Right, so in my first article in 2007, I proposed that, as I mentioned, there should be experts who could opine on the poetics, right, the construction, the artistry behind rap music. Without saying it, obviously, I think in many instances they would be defense experts because the government has its own law enforcement experts who I think are wholly unqualified, but that's another conversation, to opine. And I propose that courts should allow defendants, those who are accused, to offer a defense expert who could situate the lyrics, the creativity in context for jurors in particular. In the end of the book, we offer a number of proposals, also legal reform proposals, so that there should be the creation of statutory rules restricting the use of rap music as evidence, and evidence nullification, right? This notion that jurors, right, so long as they are impartial and they, right, listen to the facts and the evidence and they follow the judge's instructions, have complete authority to nullify evidence, to disregard evidence that the government has offered, and that we should educate them on this particular ability and responsibility. And then that people should vote, right? Your judges, right? Your prosecutors who are locally elected, right? You have the ability to change the decision makers, right? And the participants in the system, and you can do this by voting, right? And so I think what many people have hit on and undertaken from that time are twofold, right? One is the voting, right? And so it resonates with particularly lay people who aren't involved at all in the criminal legal process, but they understand that they can vote. They can make decisions about who might be their prosecutors, who might be their judges. Now, I will say, again, for another conversation, the progressive prosecutor or the prosecutor who indicates a willingness to abandon this type of evidence, once elected, may or may not have different pressures or perspectives, right? I'm not always going to say now that a progressive prosecutor is going to abide by their agreement to, right, look critically at evidence and not pursue certain strategies. We've actually seen that happening on the ground. So that is one path that has been taken. The other is a legislative response. And here, when we proposed that there should be rap rules of evidence or criminal procedure, I guess despite the last panel and my comments, I'm less wed to where they are. But in any event, various jurisdictions have, lawmakers in various jurisdictions have proposed or introduced rules. So both in the federal system, in Maryland, in New York, in New Jersey, in Illinois, and in Missouri, there was even a proposal in the Atlanta City Council in response to prosecutions in the YSL case and other cases in Atlanta. All of those were introduced and none of them passed. I'm California, and I know we're going to hear from someone from California, right, did enact its law, and as well Louisiana enacted a law, which I think is interesting both because, right, you have this, within rap music, hip hop, you have the East Coast, West Coast, right, New York, LA divide, so you have New York not enacting its law, but you did have California enacting its law, and then Louisiana, which, depending on your knowledge of hip hop, right, actually is a strong presence in hip hop and rap, in that industry and in that creativity and production. And so Louisiana did enact a law. And so we will see over time whether more jurisdictions have these types of laws introduced and or enacted. I will probably comment that I am watching. I am watchful to see what happens. Many of the laws, the proposals that have been introduced, I think maybe consistent with my participation here, don't go far enough, right? Are not critical enough, right? They are remixing, to use a term, right? They are restating essentially what should already be understood to occur under the rules of evidence and consistent with judicial right responsibilities and expectations. And so I'm interested to see what those proposals in California and Louisiana do ultimately as we have more decision making in light of those rules. I would be excited and delighted to see other proposals, right, that do more. And obviously as a researcher to create, right, a laboratory, right, of study, right? If we have some stronger rules, so to speak, some weaker rules, so to speak, right, that will allow for some study to see what happens in the future. So I think, right, the legislative response is happening, and to my surprise, I never thought we would get any proposals, much less enactments, but I think it remains to be seen. I'm not going to, endorse any particular approach at this point, and maybe that's consistent with my deliberative nature and my researcher's philosophy. But I think what we've also tried to do is support social science research, interdisciplinary studies about this particular issue. So when we've had sociologists or psychologists approach us, or when we've reached out to them to study various issues, whether it's related to implicit bias, or unconscious bias, depending on the term you like to use, or how it is that individuals communicate about themselves and their world, whether it's through creativity or social media. That is, social media has become both an intersecting phenomenon, but also its own phenomenon in and of itself, its own form of evidence, right, that raises many of the same issues. So thinking about social media much more broadly, about how individuals communicate and express their world view through social media. We've also focused on expanding legal expertise, right? As I said, I've been thinking about this for over a decade. There aren't so many others who have joined in. I would love to have a collective, right? I don't want to be out here alone by myself. I would love to have others to brainstorm with. And so we do have, consistent with that East Coast, West Coast, again, the University of California, Irvine has a First Amendment clinic that's done some work in this area. Howard University School of Law is beginning to do some work in this area. And so I think those are very important moves as well. To someone's point about training of experts. So people often call me and say, well, you should be an expert in my case. You know all about this field. And I know a lot, right? I also know that many judges do not want a legal expert. They do not want someone to come in and tell them how rules should be, right, analyzed, right, what evidence should or should not be admissible. So I'm not the appropriate expert. So I do a lot of work letting attorneys know that I am not the expert you want. What you need is a rap expert, a hip hop expert, right, a social media expert. But there is a limited pool of those individuals who both know that they could be this kind of expert, are willing to be this kind of expert. It is particularly challenging to be an expert, to be a witness. And so trying to train a crop of individuals to serve as experts has become one of the moves that we're trying to make in terms of implementation of proposals. And again, to this California, not only do they have their rule relating to the restriction on rap music, but they also have a Racial Justice Act, which, if you're not familiar with it, allows for post-conviction challenges to evidence of a racial or racialized nature. And I say that broadly in that way. And so that there have been challenges on the basis that rap music was used, and that is racialized evidence, and so that should be impermissible. And so they're developing a host of experts who can testify in that regard about racialized evidence pursuant to proceedings related to the Racial Justice Act. And so I think that is both distinct but also quite closely related. And so I'll end with just talking a little bit about the future as well, for other implementation and reform and hopes that I would see. I think one is to encourage judges now to appoint court experts, right? We often forget that judges have the ability and authority to appoint an expert, right, to help the court, to assist the court, right? To assist the court in decision-making, to assist jurors in decision-making. That would be neither a prosecution nor a defense expert, so to speak, in theory, an impartial expert. And I think that is an interesting option that could be pursued. I think the next effort is to educate judges, and in particular, their law clerks. So I am always delighted to talk to students, right, who become law clerks, who can help their judges understand all sorts of novel issues, or what to the judges seem to be novel issues. But also educating pretrial services officers and probation officers who are using this type of evidence at the behest of prosecutors in pretrial decision-making, whether or not individuals are released pending adjudication, right, into the community, or whether individuals are sentenced and sentenced more harshly based on their rap creations. And so helping to educate other participants within the entirety of the criminal legal process to understand this evidence generally, but also reframing rap and hip hop within the criminal legal system as pro-social, right? We know that we come to this with this understanding that it is antisocial, right? And that it is evidence or indicative of antisocial behavior and criminality, right? But understanding that actually it is, for many individuals, right, it is an outlet, a therapeutic, creative outlet for emotions or experiences, right, that it is an actual way out of their communities within which they might be stuck, right? Many of you have probably heard, right, for many young Black and brown men, right, there are only 3 ways out of their life circumstances, right? If you're an athlete or a baller, right, which means you have to have certain skills, right? If you are a rapper, right, which means you also have to have certain skills of a different kind, or in a body bag, right, because you have been involved in criminal activity and you're killed, right? And so rap actually can be a pro-social way out. And understanding that you might actually leverage creativity to support rehabilitation, right, to support pro-social activities, to support therapeutic needs, and that there are actually programs, right, in many cities and communities that use and leverage rap music and other forms of creativity as pro-social, and that the criminal legal system, instead of looking askance and skeptical and resistant to rap music, could actually leverage it in a positive way. And then to think about cases involving juveniles being adjudicated in delinquency court, student discipline cases and corrections, right, as was revealed, cases or circumstances in which the evidence rules either do not apply or loosely apply, right? I think part of thinking critically about evidence is thinking about, as we heard, those spaces in which the rules don't apply, or they are applied in different ways with differing outcomes. And so trying to think about this particular type of evidence and related types of expression in those particular contexts, and where the stakes can be equally as high and the so-called rules are not operating with any or much force, even less force than in the criminal legal system. And so then the last thing I'll say in bringing me back full circle to my initial comments, when I first wrote about this, as I indicated, I was thinking about this from the lens of criminal defense lawyering, right? And then the rules of evidence, right? Character, other acts, expert rules of evidence, equity or parity between prosecution and defense, right? Fast forward 15 years later, and I'm at a point where, trying to rethink this work through the lens precisely of evidence and critical evidence. And I think, that's a recasting, a recharacterization, or a remake, right? Again, if you want to use a musical theme here, it's a remake of earlier work. But I think that means connecting it to many of the larger issues about surveillance, as I mentioned, thinking about how we adjudicate collective activity, right? As was mentioned, right, the Atlanta cop city prosecutions, right? In those cases, it's not just the phone number being written on an arm that is suddenly now used as an overt act for RICO, right? There are also individuals whose journals, I won't call them diaries, but journals and notes, right? That effort to use what was written either creatively or therapeutically, right, as circumstantial evidence or direct evidence of criminality. And the using creativity and expression that relates to fashioning or envisioning one's world, and understanding that the government is using that using that evidence to undermine those who are resisting the system, right? To undermine those who are othered in the system and in society, right? And so for those who create rap music or other forms of expression, right, who are othered, right, now that is being used against them, weaponized against them. For those who are resisting the system, right, who are seeking to abolish, right, certain aspects of the system, now their expression, their self-expression, right, is being used against them as criminal evidence. And so I think beginning to think about the work I started 15 years ago that was just a quirky little issue that seemed so obvious to me, why we weren't pulling on other disciplines, but now in a much larger lens. And so that's it. Thank you.
Hello. So when our wonderful organizers asked me for a preview of what I wanted to talk about today, I said, well, I really want to talk about my achievements on the topic of prior conviction impeachment and its reform, but I hasten to add that I would follow that up with some of the complications and difficulties in attempting such reform. So that's what I'll do today. I'll talk about these achievements, and then if time permits, we can get to the complications and difficulties. First big achievement was agreeing to collaborate with Julia Simon-Kerr. She made a great first intervention, which was to suggest a meeting and to point out that we've both been writing quite a bit about prior conviction impeachment, which for the newbies in the room is the use of convictions to attack a witness at trial, purportedly on the basis of it being a way of showing that they're not being truthful. We'd both written about various problems relating to the probative value of that kind of evidence, various difficulties in terms of the unfair prejudice that it can cause, including, to borrow Professor Gonzales Rose's term, the racial prejudice that it can cause. A bunch of other scholars have been writing about this, brilliant people, and yet nothing really had changed significantly in the last few decades by way of reform. And she said maybe we should try and do something about that. Moreover, she's been the perfect collaborator, in part because the things that really interest her and some of the things in which she's become totally expert are way over my head, and I've got nothing to offer on them, including she has immersed herself in the relevant social science literature, so that she's able to say with confidence and with gravitas that the notion that these convictions speak reliably on the issue of witness truthfulness isn't backed up by the data. She's also immersed herself in the history of the predecessors of the existing prior conviction impeachment rules, so that she's able to say with confidence and gravitas that these rules perhaps were never really going after truthfulness, but rather were trying to mark those folks who could be deemed worthy of belief. a related but importantly different concept. And she's been gracious on her part in allowing me free rein to go into the topics that are more my cup of tea, such as, for example, the vast state variety in how rules governing prior conviction impeachment are drafted, how they're made, and what they say, including the fact that 3 states have decided that those on trial in a criminal context should not be permitted to be impeached in this way. The second achievement was agreeing that Julia and I should not just work together, but should form a coalition. That 2 was stronger than 1, but even stronger than 2 was the 10 or 12 wonderful professors who've joined with us as part of this coalition for prior conviction impeachment reform. They're all over the country and they're writing about all sorts of aspects of this issue, but they've been a tremendous support and help as we engage in our litigation efforts and our academic presentations. Shout out to those in the room and on Zoom who are part of that coalition, in addition to Julia, Bennett, Jasmine, Montre. They've all enormously strengthened our work and our thinking on this topic. The third thing that's been wonderful is that I've been able to go back to worlds that I thought were closed to me, and that's always reassuring. In this case, it was the worlds of defense lawyering and the world of Washington State, where I used to live. And the 2 came together in the following way. We were lucky enough to get some funding from the National Association of Criminal Defense Lawyers to do some of this work. We wrote a report with them, which is about to drop, on prior conviction impeachment in terms of the national picture. But with their guidance, we decided to include a chapter that was state-specific, specific to Washington State. And with their guidance, we also decided to start our reform efforts in Washington State in the hope that reform there would ripple outwards, as it has in a different context. Washington State was a pioneer in terms of reforming peremptory challenges, and their changes have been influential. Why did we choose Washington? Well, there were a couple of reasons that I'll go into. One was their Supreme Court, which is trying to do all sorts of interesting things. And in particular, I remembered that when I had lived and worked in Washington State and presented to their appellate judges on this topic, a state Supreme Court justice had approached me at the end of the presentation and said, I hadn't really had on my radar screen the kinds of issues that you're mentioning, including the racial justice issues. And because we, the state Supreme Court justices of Washington State, draft or oversee our evidence rules, I invite you to make a rule change proposal. It was frustrating to me then that I left the state and that idea sort of died, but we've been able to bring it back to life and draft such a rule change proposal. A second reason why Washington was appealing as a focal point is that they have a wonderful, vibrant, progressive, effective defense community. And it's been extremely gratifying to be able to work with them, and despite their brilliance and their expertise, to feel like we could offer something, because several of them said to us, we've been laboring under this rule for years. Far more importantly, our clients have been suffering under this rule for years, and yet we never thought that we could play a role in trying to change it. And so it's been wonderful to see them now citing the scholarship and pushing aggressively to have the rule either changed or radically reinterpreted. And the final wonderful thing that I'll mention has been the amicus briefs that we've been able to work on, again with fabulous collaborators, including Jasmine. They've brought us the experience of collaboration with a variety of folks, but also brought us insight into various state constitutional provisions that I hadn't known about. It's a particularly exciting time for us now because we have amicus briefs pending in 2 cases, one of which is in Washington. We're hoping the Washington State Supreme Court will hear it, and it includes a constitutional argument under their state constitutional provision that protects the rights of the accused. It's arguing that part of their rule is unconstitutional. And then a second one that's pending in the Oregon Supreme Court. This is a federal due process challenge because they don't have a state due process clause. And again, it's trying to bring down a big chunk of their prior conviction impeachment rule, which makes all felonies mandatorily admissible. If the prosecutor offers them, the judge has no discretion to keep them out, no matter the unfair prejudice that they may wreak. Complications. First of all, as has been alluded to, and as now seems obvious, it's a lot harder to propose a regime than to point out the fatal flaw in a regime. And that became most salient for us, I think, when we were trying to figure out what to do about convictions being offered by the defense in a criminal case against a prosecution witness. given Julia's research into the very limited, perhaps non-existent probative value of these convictions, it might have been most intellectually consistent to say, well, nobody should be able to use them. But I couldn't quite reach comfort with the notion of proposing that the defense should be stripped of this power, which just sometimes can push back a bit against governmental evidence. And after all, the defense does have a constitutional right to confront. So after a lot of talking, she and I, and back and forth, and very courteous tussling, I think we've now reached something we can both sign on to and still sleep at night, which is a proposal that this form of impeachment be abandoned, except where abandonment would violate the constitutional rights of the person on trial. We've put that down in writing somewhere. Second, it turns out that these rule change efforts move quite slowly. I like a quick victory, and this is not that. Again, under the tutelage of the experts at the NACDL, we didn't just march in there with a rule change proposal. We're supposed to be doing a great deal of laying the groundwork, building the coalition, networking, politicking, back-channeling, webinars, trainings. I did my best. I am continuing to do my best. But at one point I just said to Julia, why don't we just draft a rule change proposal just to get it out and maybe circulate it a bit? And so we did. Third challenge is that there's a lot of things we don't know how to do. One of which is how to build a wonderful website. We have this vision, all the things we've created, all the things we could do, bringing everyone together, mapping the existing regimes, visions for change, public support building. It's still to be done. Second, we don't know how to find or invent the ideal expert within the social sciences who is deeply versed in indicia of truthfulness, as well as fully understanding the legal issues at play, and able to be a persuasive visionary who will revolutionize the landscape. We haven't found that person yet. We don't know how to bring in the public most effectively, whether it's even plausible that this could be an issue that could resonate broadly with the public. And I suppose we don't know whether to just keep waiting for opportunities to land in our inboxes, as they did with the Washington case and the Oregon case, or whether we should try to devise and mount some kind of nationwide campaign, or at least figure out where we want to go next. And finally, the biggest and most profound one, and I'll talk about it only briefly because Maneka's been a pioneer here, and Jasmine has also kept me honest on this one. And that's this: if you're moved by abolitionist commitments, if you, as was mentioned earlier, profoundly doubt the potential of courtrooms to realize visions of truth or justice, what was the other one? Fairness. What are we doing calling on those visions in terms of, as we push for change? Are we at risk of papering over the vast disparities that precede what happens in the courtroom, pervade what happens in the courtroom, and will follow what happens in the courtroom? Is there a way that we can isolate some of these state provisions and say these are egregious without seeming to endorse the other ones? Or is there a way we can point to prior conviction impeachment as egregious without seeming to endorse all the other things within the criminal evidentiary systems that do just the same thing, that reinforce racial subordination, that chill people from testifying, that deter trial, and that give weight and meaning to a conviction that I don't think should be given, or that ignore social science and rather turn to ameliorative assumptions that have no basis, such as, well, just instruct the jury and everything will be okay? Is there a way, in other words, that somehow we can use this as a case study that might open the way to broader visions of change, rather than seeing it as an anomaly that just needs to be fixed? Thank you.
I think I'm up. I'm going to start the way some others have, which is I just want to take one moment to thank the Journal for convening this fantastic symposium. It's been such a robust and engaging conversation already. I'm just delighted that you thought to invite me, and I want to thank Taylor Ann and Alyssa in particular. I'm delighted to be here with this slate of panelists whose work is so groundbreaking in this field, so thank you for putting it all together. As Professor Simon-Kerr said, I do focus on forensic evidence and forensic tools and Rule 702, which is the rule that governs the admissibility of expert evidence. And I've been trying to situate the role of forensics in the carceral process. And so I'm going to start by saying something that seems fairly obvious, which is forensic tools and forensic evidence cause carceral harm. But I want to clarify that point just a tiny bit. I don't just mean wrongful convictions. I say that because forensic tools cause carceral harm even when there is no conviction, and even when the conviction is not quote unquote wrongful. And as Professor Collins was saying to me in the car ride over, the issue with forensics is partly about whether or not they're reliable, but it's about other things too. And I say that because by performing a surveillance function, by performing a monitoring function, by performing an investigation function, by performing an identification function, these tools suck people into the carceral machinery, and that subjects them to a harm regardless of whether what the outcome is. And I also want to clarify one other thing, which is when I say forensic evidence, I'm talking not just about your traditional CSI methods like your DNA analysis and your fingerprint analysis, but I invite us to think more broadly about the concept. I think of it as surveillance tech and facial recognition and predictive tools and all of these new algorithms that we see, any sort of tech or purported tech that serves a carceral function. And so when I try to situate the role and the harm, I think it's important to point out that not everyone recognizes the reality that forensic methods, for the most part, have entirely carceral origins. They're designed and developed specifically for carceral purposes. And many are, again, not the only point, but many of them are entirely unreliable or used in really unreliable ways. Rule 702, to some extent, is supposed to protect against those types of harms by filtering out the bad stuff, by filtering out the junk. But in reality, Rule 702, it seems to me, can actually help prop up the legitimacy of the carceral apparatus by creating this appearance that this type of evidence is being vetted by a judge, much the same way a lot of the other rules of evidence do. When you look beneath the surface, though, you can see that the check is not very robust in the average case, and there are a lot of reasons for that. One sort of underexplored reason for that is that carceral actors, like the communities that produce these tools or use these tools, they know the rule, right? They know what it says, they know what it requires, they know how judges apply it, and they can either navigate around it or manipulate appearances to sort of manufacture a veneer of reliability. So I'll give you an example. One of the ways in which we sort of apply Rule 702 is by looking at a case called Daubert, and has these factors that you look at to determine whether a method is reliable or not, and one of them is whether it's been peer-reviewed. And so I work at Maryland Law School, I teach there. I could write a paper, and I could write a paper that says Maryland Law School is the #1 best law school on the planet. And I could share that paper with my colleagues who very much agree with that proposition, and they will, stamp of approval my paper, and then I can give the paper to my dean, who can wave it around to US News or whoever and say, well, Maryland Law is, of course, the #1 law school in the country. I have this peer-reviewed paper to show you, to prove that up. And everyone in this room who is at another wonderful law school is looking at me like, you're a crazy person. That's not how that works. And I'm obviously exaggerating a little bit, but when I say they know the rule and they can manipulate and navigate the rule, essentially that's the type of thing that I'm talking about. We also know that judges don't hold hearings. When they do it superficially. We talked in the last panel about how they apply the rule differently depending on what side is offering evidence. So the quote-unquote gang expert comes in under the rule, whereas maybe our rap expert or the racism expert gets greater scrutiny. So for all these reasons, the rule is not sort of working in the ways that we want it to. And as I've been thinking about how to try to reckon with all of that and remedy some of those harms, those problems, I've been thinking about how do we look at abolitionism to construct a framework for evaluating reform in this forensic space specifically And that could be proposals that people make to how to improve the system. It could be how to evaluate the rule itself or amendments to the rule or to the forensic system generally. And I wrote an article about this about 2 years ago where I proposed a framework with 3 prongs. It's imperfect, but hopefully it's a starting point. And prong one is going to be fairly obvious. It's to sort of evaluate the reform for consistency with basic tenets of abolitionism or non-reformism. So for example, when we look at a reform, we ask ourselves, is it legitimizing the carceral process? Is it expanding the carceral state? Is it avoiding harm production? Is it building something for the community that's beneficial for the community rather than producing new harms? The second prong, because forensics are interesting, is to categorize the tool or the method or what we're using it for by its purpose. And I say that forensics are interesting in this context because the forensics could have legitimate non-carceral purposes, right? We could see communities wanting to use certain tools for things like identification, but not punishment. And so we have to evaluate what the purpose and how the tool or the reform or whatever the proposal is being used. And then the third layer is to categorize by the actor. Who is using it matters, because again, if a community decides that a certain method might be helpful for a non-carceral purpose, we might think that's just fine. But if we're looking at a tool that's used primarily by police, prosecutors, or their allies, other carceral actors, that's where we might consider more restrictions, where we might consider that is not a reform that aligns with that vision of abolitionism. And I can give you an example of how this might play out, because I think that when you try to apply this framework, you get sometimes interesting or surprising results. And so one of the things that is commonly discussed in the forensic space about what type of reform should we try to push forward, one is independent labs. So I'm talking about labs that are doing the work that are not associated or affiliated with the police. They're carved out of the police department. And if we apply prong one, we're kind of it's sort of unclear where we come out on that. It could be consistent with non-reformism, particularly if we're divesting from the police and we're taking that money and we're creating something independent that is not affiliated with the police. It could be. But when we get to the other 2 prongs, it becomes a little bit more, it have more clearly carceral function. So what's its purpose, right? The lab is independent, right? It doesn't work for the police, doesn't work for the defense. But at the same time, the work that they're producing is still for the carceral system, right? So it's still going to be used in court to police, to prosecute, in search of convictions. So the purpose is still purely carceral. The last independent lab that I worked with very closely is in Washington, D.C. Police and prosecutors are its primary stakeholder, right? The defense doesn't have access to the lab. The defense isn't allowed to do their own testing. They're not allowed to call up the lab and say, can you test this thing I found? They serve the police and the prosecution. And prong 3, this sort of who's the actor that's using it, again, same thing. The lab is their work is being used and in the courtroom being leveraged by the carceral actors. And so I just wanted to use that one example to sort of think through how this framework would look. It's imperfect and it's challenging when you actually take a reform and try to apply it through this, or sort of look at it through this lens, but hopefully it's a starting point for thinking about what reform could look like as we, to sort of build off some of the conversation that we've been having. Some of the underlying thread here has been sort of hesitancy, in Professor Caper's comments and Professor Roberts' comments, about whether the rules themselves are the proper site for reform if you're thinking about it through an abolitionist frame because of the carceral logics that underlie the rules. So what I'm trying to do is sort of think of a framework that we might look at external to the rules themselves. So I'll stop there. Thank you.
Good morning, almost good afternoon here. This is incredibly exciting for me to be here because here we're in a room where we're talking about critical perspectives on evidence, something that preoccupies my waking moment. So this is just fantastic, fantastic. Maybe after this it will permeate my dreams as well. So what fascinates me is, as a law professor, knowledge, right? Knowledge and truth. And what I see when students, because I see so many students that I've been meeting students here who are all so brilliant, is the process of law school so often is you arrive with these sources of knowledge, your truth from your community, and then you begin the 1L year where every time you have an idea, you have to cite to a white male heterosexual voice, like whether it's Blackstone or a case, a judge, so whose knowledge are we talking about? And we see that replicated in the court environment, and we see that replicated on juries that are not a true body representative of the community, right? Juries are disproportionately white. And when we think about criminal defendants, the accused are disproportionately black and brown people. And so what sources of knowledge do the fact finders, these juries in jury trials or these judges in bench trials, what are they relying upon? Do they understand the lived reality of people of color in the United States? And so a question that I've really been thinking about is, do people of color have an equal or unequal evidentiary burden? And historically, it was very clear that the evidential burden was unequal. So there were race-based witness competency rules throughout the United States. And some of these rules precluded people of color from testifying at all. Others precluded people of color testifying if a white person was a party or testifying against a white person. Now, thankfully, these all have been eradicated, but does it exist in some way? So if we think back historically and we think about how violence occurred against people of color, an example being People versus Hall in the 1850s in California, where a minor of Chinese descent was slain by a white man, and the only witnesses were other people of Chinese descent, and how people of Chinese descent were deemed incompetent to testify against a white person, or a case that came out of Kentucky where two white men slain. It was a horrific axe murder, 3 generations of an African-American family in their cabin while they slept. And there, the only witnesses naturally were black individuals, and their testimony or even the dying declaration was not allowed. And so here, not being able to talk about racism, that racism existed in its most extreme form, was precluded. Well, what about nowadays? We don't have explicit race-based restrictions, but my co-author, Cis, and I, we argue that this continues in more subtle ways. So after 2020, there's increased awareness that racism in its individual and structural, systemic, and institutional forms exists, right? It exists, and we're talking about how it exists, particularly in criminal justice or criminal injustice. But how do you prove racism in court? How do you prove that racialized reality of people of color who may avoid contact with police because fearing the indignity of racial profiling, police brutality, or bringing in state surveillance or intervention if they come from a mixed immigration status or maybe out of status? So how do you prove that reality versus the white racialized reality that only the guilty fleeth? You'd only be guilty if you have a consciousness of guilt, and you'd only flee if you have a consciousness of guilt. And so lay witnesses should be heard. People should be heard about their own racialized experiences. Lay opinion should be allowed. However, experts may be needed in some contexts, and how equipped is the legal system to allow anti-racist experts to speak? And so we've been thinking about this, and we have not just been using our own brains, but surveyed over 700 criminal defense attorneys who have shared about their awareness of, the need for in their practice, and also the barriers to having anti-racist expert witnesses testify. And here there's a lot of different ways this could happen. So how do you prove racist affiliation or views? So how do you show that someone's a member of a white supremacy group? How do you show that certain language has coded racist implications? How do you show how structural racism, such as has been shown in stop and frisk and so forth, how do you show implicit bias, such as cross-racial witness identification? What about the trauma of racism and how that may impact individuals' behavior around law enforcement officers and so forth? So we've been engaging in this work, we've been exploring how experts might be employed, recognizing they are not a panacea, this is not, they're problematic, but can experts? So I want to turn it over to my co-author to talk a little bit about some of our findings and also some of the barriers that, that exist.
Yeah, thank you so much, Jasmine. I just want to talk, because this is a reform panel, talk a little bit about the barriers that we're seeing to introducing such testimony. And there's obviously barriers that we've unearthed in the case law and talking to people, but this kind of focuses more on what we heard from criminal defense attorneys in particular. And before I kind of get into the barriers, just like a lot of people on this panel said, these barriers focus on what the challenges for attorneys on the defense side are when they're thinking about bringing in social scientists to talk about the impacts of racism. And through the course of our paper, we talk about how there's a totally different evidentiary burden for people like gang experts, for people like, for bringing in things like rap lyrics, for all these counterterrorism experts who will come with one theory and say, yes, this person belongs in the Al-Qaeda, and this person belongs in the Al-Qaeda, and this person belongs in the Al-Qaeda. Same with police experts. So we see that they have a totally different evidentiary burden, and they're admitted a lot more liberally and permissively as when we compare them to kind of like experts being brought in by criminal defense attorneys. And so hoping to just talk through some of those barriers right now. And a lot of these barriers kind of fall along the prongs of 702, and I'm trying to think about what these judges are coming up and what are their reasons to say this is inadmissible or this expert should not be allowed. So questions like, is this expert qualified to testify? Is this expert by knowledge, skill, experience, training, or education? Is this adequate? And a lot of times, a lot of people of color may not have the educational qualifications that judges are looking for. A lot of experiences of racism, like Jasmine mentioned, like so many people here mentioned, are personal experiences of racism. And these people should be permitted to testify and are probably more qualified than anybody else to testify, but are unable to do so on those grounds. Similarly, there's a prong that asks, does the testimony assist the trier of fact? And we see judges looking at white supremacist symbols or slogans and say, oh, the average juror already knows about this. So this won't really assist the trier of fact, and kind of like exclude relevant testimony on those grounds. And finally, there's this question of like, is this testimony reliable? And a lot of people have focused on Daubert here, and Maneka just spoke about it. It's about Daubert was not a standard that was designed for social scientific expertise, and then these judges manufacture different prongs, they apply them differently, and we've seen this happen in a lot of cases where judges are simply conclude that experts with social scientific methodologies are not providing reliable testimony. Then there's a new prong, and this was amended in December of 2023, which looks at whether the testimony reflects a reliable application of the principles and methods to the facts of the case. So for example, there are experts. For example, we see in a case that there's an expert on false confessions, and the defendant here is an immigrant defendant, and the judge says this particular expert on false confessions may not testify in this particular case because this immigrant has been in the country for 10 years, and their testimony does not, or their research does not look at how it would be tailored to this specific case. And finally, I think we've spoken a lot about questions of relevance today, and we see a lot of this evidence about racism being excluded because attorneys are arguing that it would be unfairly prejudicial to bring those into courtrooms. And so similarly, kind of like playing around with the standard of relevance, what constitutes relevance, and when you kind of combine questions of reliability and relevance, especially when some of those things are not clear within the mind of the judge, we see a lot of those testimonies being excluded. And so these are more like admissibility barriers, and we kind of expand on them through anecdotal evidence of surveyed criminal defense attorneys, as well as examples from the case law. But there are also massive reports of the accessibility barriers to these types of experts. And I think Andrea here spoke about some of them in the context of bringing in experts on rap lyrics in court. And similarly, we see a lot of people, defense attorneys in certain states, who are also, their offices are underfunded. They are like, we will have to get an expert from so far away, we're gonna have to fly them down. There's all these questions about whether this testimony would be admitted or not. Our client thinks this is not worth the risk, so we're not gonna go ahead and bring this expert in. So there's also these like costs and availability of experts kind of barriers that we're noticing. And finally, like a lot of the data we collected focused on like attitude barriers / perception barriers, and that kind of focused on the attitudes of judges. A lot of judges are highly racist, and what they would do when they kind of hear such testimony. Similarly, a lot of folks are very skeptical about bringing in this evidence before jurors or all white jury panels to be like, this jury is gonna think we're playing the race card, and therefore this is gonna have tangible detrimental effects on this particular client in this case. Similarly, a lot of folks have reported how prosecution doubles down on cases where things like anti-racist expertise or these new strategies are being introduced. And a lot of attorneys have spoken about their own kind of inability to spot racism in their clients' cases, their own inabilities to litigate racism in their clients' cases, and kind of think creatively about strategies to bring in different experts. So these are some of the barriers that we kind of found through our surveying of these 700 defense attorneys. And because this is a reforms panel, just to kind of touch a little bit about what we're thinking about, like Jasmine said, anti-racist experts are not a panacea. We think lay fact witnesses are important, lay opinion witnesses are important, judicial notice of racism has to take place. We need diverse, truly representative juries. And all of this should be accessible and utilized. And there are obviously persuasive recommendations that say, break down 702. 702 shouldn't exist. There should not be a binary between expert witnesses and lay witnesses, especially when they're testifying about something, about their personal experiences, and they are truly the experts on this. And we don't disagree with any of that. We think that the legal system would just benefit from some research into these proposals and interdisciplinary inquiry into what changing the standard would look like. And those particular points, we need to have the feedback and like input from community leaders, incarcerated people, their family members, attorneys representing indigent defendants, and so forth. And so a couple other propositions we came up with. We talked about the importance of training judges. Like, why is this evidence relevant? Or why is this evidence something that would assist the trier of fact? Similarly, we talked about the need to train defense attorneys, think about how they can creatively use such experts. We've also been talking a lot about needing to tap into this pool of scholars who are doing research on racism and can come into criminal trials and show why a defendant's conduct, a defendant's attitude, a defendant's how racism infected their particular case. And we know there are several reasons why people are hesitant to serve as experts, but kind of just opening up that possibility, and also at the same time pointing out to them how if they serve as certain experts for prosecutors, how their expert testimony can be weaponized for very, very racist ends, as we've seen in several of these cases. And finally, we've seen the California Racial Justice Act, which kind of thinks about and contemplates the need for experts, waiting for some time to pass to see how legislations like that consider the need, consider introducing experts on issues of racism, how all of that pans out. So those are just some reforms and recommendations we thought of. Thank you for listening.
Okay, so I think we have about 20 minutes. So I think what would make sense is just to open to audience questions, because I have been informed that there are many questions for this panel in particular, and I want to make sure we have time for them. Professor Capers.
So great panel, 2 questions. And, I was thinking about this when Anna Roberts was speaking, and then again when Aziz was speaking. So it seems to me if we really care about reform, maybe one of the first steps is to communicate all these ideas to the defense bar. And I'm just wondering if there's any sense of how you're doing that or ideas about that. Like even, Anna, when you were mentioning like 609 challenges, bringing up like this is unconstitutional under state constitutions, a due process clause. I don't know how many defense lawyers are even thinking in those terms, or how many defense lawyers are thinking about expert testimony. So that's one question. How do we get this message out to the defense bar? And then the second question is, I don't know, we're in a world of pleas now, so I also have to wonder, like, if everybody's pleading guilty, like, how do we sort of like make reform in a world where we know that there are very few trials, but we still want reform and we want it to trickle down to the world of plea negotiations?
I can throw a quick thought out just absolutely to endorse that we've thought it very important to get the word out to the defense bar, and we were very fortunate with this contact with the National Association of Criminal Defense Lawyers, which put us in touch with a bunch of folks and facilitated a training that we conducted in Washington State. We've also written a sort of easy to digest version of some of the things I said that went out with the magazine that the NACDL puts forth. So absolutely agree on that front.
So I would just echo that sentiment. One point that I didn't mention, but I hope was obvious, but maybe not, was that over the years we have done a lot of training. I have done a lot of trainings for defense organizations, both state defense bars, local defense bars, online trainings, virtual trainings, right? I do NACDL. So it's labor intensive, which I think though speaks to the point about reform and implementation is labor intensive, right? It's in some respects easier to think about the theory and sit and research. It's actually much harder to make productive strides on the ground. But yes, I think it is significantly important. But that's also why I indicated, right, when we teach our students evidence, right, that is also part of the training, right, seeding the ground for those who are coming next. But yeah, it does take a lot of effort, which is partly why I said everybody needs a group, right? Because it's so hard to do all of the trainings. And when criminal defense lawyers hear about this work, they become very interested. But then it becomes harder, right? Because you can't satisfy all of the requests.
Absolutely. I think it's so important to have these trainings, to get the information out here, to raise awareness. And, I'm doing a training on Wednesday for judges about racism and evidence in Massachusetts. Really excited about that. And then also your question, Professor Capers, it's true. We're talking about trial, and hardly anything goes to trial. I probably am overly optimistic because that by nature, but the idea that if racism is better known, if it can, there's the potential it could be proven that somehow that could be in the equation, in the plea equation, and so forth, so that perhaps it can continue in the shadow of that this evidence is possible, is the hope.
I would just add to that in terms of the plea, the scenario we're describing where just so little goes to trial. A couple of things that come to mind is one of the reasons I'm trying to think of a framework that's outside of the context of the rules is that we might be able to do some reform work that does the work of the rules, sort of before it has to get into the courtroom. So it's much clearer in the context of forensics, right? Like we can look at reforms that do try to vet reliability before something can go into use, regardless of whether it's going to be used in a courtroom or not, just use at all by police. So we can enact legislation that might do that. And then another piece is, I've obviously been talking about looking outside of the rules of evidence, but I have advocated for use of rules in different contexts. I know many people have written about how sentencing doesn't have these procedural requirements, but thinking about how we might apply some of the frameworks in other stages of criminal prosecutions. And so it's not a complete complete solution, but those are some of the ways that I think I'm thinking about it too.
So maybe my last comment on that point too, right? I mentioned, right, encouraging the education of pretrial services officers or probation officers, right, law clerks, those who are involved in, right, those pre and post adjudicatory phases in which they have a lot of discretion, and so somehow trying to educate them, send them articles. We encourage defense attorneys, send them articles, send our book, point them to the website, right? Help educate them as they are making their recommendations to the courts on either end become significant. I think for me in particular, again, this has been a long, slow movement, and while I am not overly excited about the complex celebrity cases, what they do is two things. They increase the public narrative and understanding, and so that also, I think, then affects judges and decision makers in the process, right? But also for those well-resourced who are accused and they can continually litigate this, right? They are able to change the law in small ways, I think, which, of course, as we know, the law, right, functions as a large weapon, right, or tool in encouraging and enforcing pleas. And so if we shift, right, the law a bit to say to prosecutors and law enforcement, it's going to be more difficult to admit that evidence than you expect or than it previously was, then we shift, right, the balance just a little bit. And so that's part of a very multi-pronged effort to make any reform.
Thanks. Professor Cheng.
I'm struck by how many of the reform efforts that you all discussed involve state reform efforts. And if you think about the structure of the rules of evidence, you have the federal rules, and then the states adopt the federal rules. And my question is, how important is it that states are the place for the reform efforts to begin? My impression is that the Federal Rules Committee is extremely conservative about any kind of change. The federal rules are in many ways frozen in 1970 to the most part. But I hear states making inroads on this. So the rap lyrics legislation, California, Louisiana, the 609 efforts in Washington. I'm curious on your observations about that.
So maybe I'll start here. So let me just say about the federal proposals, much like the 412 rules or some of the 413 to 415 rules came from lawmakers, right? They didn't pass, but they came from lawmakers, not out of, right, the Rules of Evidence Committee. And so what I think that reinforces your point, right? Those traditional, right, creators of the rules, the traditional committee structure is less interested. And these sort of radical, critical proposals are coming from lawmakers who are moved by their right, constituents, right? Or in some cases moved by celebrity cases or well-known cases, right? They just want to be on the vanguard of whatever the hot issue is. I won't be too cynical. I think what I've seen in the states is similar. The proposals have come from lawmakers rather than from the courts in my instance, but I think they're much more interested in what's going on for their very right local state citizens and constituents, and more willing, maybe there's just less bureaucracy, fewer challenges in trying to move something through one state than it through the whole entire federal system.
I would just add, to your point, I think that the state rulemaking bodies are just more agile than, I wouldn't just say agile, period, but more agile than the Federal Rules Committee. And I'll give you an example. We'll see where it goes, but in Maryland, after the murder of George Floyd, the judiciary formed a committee on equal justice, and one subcommittee within that is a rules subcommittee. It was tasked with evaluating the rules and whether or not they sort of perpetuate disparate treatment. And that little subcommittee reached out to stakeholders all across Maryland, including clinics at my law school, including my clinic, and said, can you give us your advice on this? And taken up some of our recommendations, and they're making recommendations to the broader Rules Committee, and we'll see where they go. But all of that happened, in the last couple of years, which, I can't imagine happening on the federal side. So I think part of it is that.
So our coalition does have, as part of its mission statement, that will seek change both at the state level and one day at the federal. When I looked through the Federal Advisory Committee notes relating to 609, 3 things stood out. Number one, there had been numerous cogent proposals for reform, including one by a law student, so do note that you can make your efforts right now to change this, but that they'd all been rejected. Number two, the tremendous power of the DOJ. But number three, that the reporter was tasked with keeping an eye on what the states are doing. And right now, as mentioned, there are 3 that ban this as a form of impeachment against those on trial. So we're hoping to get that number up to 4, 5, 6, 7, 8, 9, or 10, then to have the reporter take a look and report that, and then to get the federal rule changed as well, I think. Is that right?
Yeah.
Yes.
Sums it up, exactly. We'll take the rest of our lives, but that's the plan. Okay, let's go over this.
Thank you. That's right, I don't need a microphone. I can project. Thank you all for coming. Appreciate it. My question was specifically directed at Rule 609, particularly, I think it's 609B. I brought my evidence book. Of course, it's in my backpack, where it's doing me a whole lot of good right now. But the specific section I'm talking about. Thank you. The specific section I'm talking about is there's the first part of the rule that talks about convictions where the punishment is death are up over a year in imprisonment. And then the second part of the rule is any crime, regardless of the punishment, that proving fraud or dishonesty was an element. Something I was interested in was that a lot of these states that have pushed for reforms just get rid of it completely, which I was a little surprised at, because from an outside perspective looking in, I can absolutely see why, like, A is something that should be gotten rid of, like whether or not somebody has a prior conviction for an assault really has no bearing on their character for truthfulness, compared to if they have committed fraud, for instance, or perjury in the past. As a potential juror, that might weigh on me a little differently, particularly if that's more recent. So what are the panel's thoughts on like that provision specifically, and have there been any discussions about that provision versus the whole rule and the top part? Thank you.
Yeah, that's a huge issue. So when we first spoke to Washington defense stakeholders, including really prominent and respected and progressive defense leaders, at least one of them's knee-jerk reaction was, well, of course you're not going to be able to get rid of the part that's the one you're alluding to, or the state version of that, right? Even to him, that's too much. And so we had quite a bit of discussion about whether we should have a compromise position that is like, get rid of the felonies that don't appear on their face to have anything to do with anything you'd think of that might be dishonesty, but we can keep these, and maybe we'll have a better chance of getting our proposal passed. So we tried a few options. I think in our report that talks about Washington changes, we do offer a menu of options, and one of them is that perhaps more palatable to some option. But our position is it's all got to go, not only because of the social science, disconnect with the social science, but also if you have deep concerns about the reliability of convictions across the board, if you have deep concerns about the way you're reinforcing racial subordination, that's not restricted to the felony conviction. So we're pushing for it all to be abandoned as a prosecutorial tool, but I totally get the concern, and it's one you have to think of in terms of real life efforts.
I think this is such an important issue, and obviously for relevance purposes, if someone has a prior perjury conviction or something like that, that seems most relevant to their truthfulness on the stand. But when we think about all the different offenses for false statements and dishonest acts, we see a tremendous amount of racial disparities. And who is convicted for things such as trying to be sure your child is in a safe school district, and so you're dishonest about your home address, or who is convicted for writing false checks and so forth. And we see a tremendous amount of racial disparity there, and class disparity and so forth. So I think the concerns are pervasive, although it does make, at least it's logical. Right.
It is logical, but if you really want to predict untruthfulness, probabilistically, you need to it doesn't work. I mean, we don't know. I shouldn't say it doesn't work, but the studies that have been done do not suggest that it would work. They suggest you have to know very granular things about people, including, you know, how do they behave in this particular situation in the past. So I think my view based on that is you would need, you might need some form of impeachment that lets the fact finder know this person has lied in a very analogous situation on the witness stand in the past, which would apply to repeat players in the system who testify a lot, and I think would be important. And I have a proposal that suggests a provision like that to replace this. Olivia, did you have a question?
Hi, yep, okay. Hi, my name is Olivia. Thank you again all for coming here and sharing your ideas, not only this panel, but the panel before and the panel that will come. I'm incredibly interested in litigation, and I'm also interested in evidence, so I'm very excited to be here. One question that I had, and I think this speaks a lot to Professor Dennis, but if anyone else has any other thoughts, I would love to hear them. What are your thoughts about rap videos that are being posted on YouTube or other social media sites not being used for the lyrics, but for potential non-testimonial evidence purposes? For example, if someone's holding what may purport to be a weapon, or might be holding what someone could tell could be drugs or something of that sense, the admission of that as non-testimonial evidence in terms of like prior bad acts or other things like that. I'd love to hear your thoughts. Thank you.
Sure. So when I first started the research, I was focused primarily on lyrics, and this is very old school, right? Because they were often found written down in notebooks, right? Or maybe you could find a tape. Does that even resonate with many of you in the room? You could find a tape. Maybe you would find a CD. Increasingly, you would see postings on MySpace. Does that resonate still? Right? That was the early sort of social media, and that's when, or you would see advertising, right? So a flyer for a concert or an album, you know, a car. Anyways, this all seems so dated. But, right, that also is reflective of the initial use of the evidence comes out of that era, right? When you had very tangible pieces of evidence. And then over time, we have seen a shift towards, obviously, virtual evidence primarily, but not solely. But that includes videos, photographs, recordings, audio recordings, and so the throwing of signs, hand signs. If you're law enforcement, you call them always gang signs, but yet they are not always gang signs. Sometimes they are simply hand signs. There's a long history of expression in the Black community of using hand signs, right? And so suddenly that's criminalized. Or, as you said, you know, displaying what purports to be weapons and or money, and then the claim by the government as well that you were actually holding a particular prohibited weapon, or you were holding large sums of cash. Two things, interestingly, I think this actually really connects to your work, because if you have simply, and what happens is those items are not necessarily ever recovered. Sometimes they are recovered, but sometimes they are not recovered. And so the pure evidence is just a visual representation. You know, I question how they are reliably guaranteeing that that is a legitimate actual weapon or legitimate money. There are very good replicas, fakes, whatever you want to call them, counterfeits. And so I have this question about, right, whether it is actually, right, reliable forensic evidence. I also know that there are some artists and creators who will write at the beginning of their videos, if you watch the whole video, whether it's the front or the back end, and say none of these props, or none of these items are real. They are all props. And what the government will say was, yeah, well, they just said that because they know that they need to say that to avoid any liability. And I'm thinking, no, they're saying that because they understand that, yes, right? They want you to understand. And so what we have done over time is expanded to, I now just sort of call it rap music evidence very broadly, to include lyrics, pictures, videos, dress, what clothes are being worn, which you might think First Amendment, you can wear whatever you want, but apparently you can't wear certain colors, or right, or certain items, or you can't wear them with more than one person, right? So clothing, hand signs, anything like that, we now collectively think about that, which is now why, more broadly, we think about it as expression, right? Which is also why we think about social media, because that is another place, different context than rap music, but it is a place in which much similar expression occurs. And so I'm skeptical of all of that. I'm skeptical of the so-called government experts without what I consider to be reliable data and reliable principles and methods, right, making conclusions about any of it. What lyrics mean, what a hand sign means, what clothing means, what it means to be in a group of young black men, taking a picture together. Why is that not permissible? But young people on a beach at spring break could take a picture together and they're not a gang, right? So on and so forth. So I would say for all defense attorneys, it's be skeptical of everything. I understand there's peril and risk maybe in your professional, right, endeavors. Maybe it could frustrate, right, the repeat players that you work with. But it's important to move forward that conversation.
And I would add it's also incredibly important to be able to articulate why something is perpetuating racial bias or emphasizing stereotypes. So, Professor Montre-Caradine, and I know some of my work has really looked at racial character evidence. So courses like critical race theory and so forth, they're not just electives, but how do you translate that to say what is being represented? What is the actual purpose that this evidence is being shown? It's being shown to show that these individuals are these certain types of people of color, and we all know all of these racist stereotypes and so forth. And so being able to articulate that is a true professional skill.
So I'm sorry, I know we're running up on time, but I want to give a very, very concrete example. And this is, if you've read my work, you've heard this, and if you haven't, I'm foreshadowing, right? So one of the pieces of evidence that I've offered for why the government uses rap music evidence is training manuals. And there were training manuals written in the early 2000s, one of which said, right, be on the lookout for rap lyrics as evidence, right? You're looking, right, you want to be able to paint the character of the defendant, right? They'll come into court looking as a choir boy. I'm really butchering the quote now because it's not coming completely to mind. But the point is, if you find this evidence, right, you'll be able to show the jurors that this is a criminal wearing a do-rag throwing a gang sign. So I had a little disagreement with a prosecutor when I served as a witness about individuals wearing do-rags was clearly a racialized statement. And he said, well, no, why would you say that? There are lots of other people who wear do-rags. Yes, I'm not denying that there are other people who wear do-rags, but what I am suggesting is that the historical and social understanding of those who wear do-rags is that it emanates from young black men. Well, why would you say that? Because I have this picture here of a Latino man wearing a do-rag. Yes, as I said, right? I am suggesting that the historical and social understanding derives from a connection to young black men, and oh, by the way, you're also showing me a young Latino man who you were going to allege is in a gang wearing a do-rag. And so that is a very concrete example, not just of so-called rap music evidence, but racist evidence from prosecutor statements in a training manual. Of course, the question is always did that particular line prosecutor read that particular training manual? I don't know, but they share stuff. So in any event, that's a very, I think, practical way to think about that.
Okay, unfortunately, we've run out of time, so we'll have to adjourn and get ourselves set up for our podcast experience. But thank you so much to this panel. It's been really illuminating.